There is a specific kind of violation that happens when someone puts a piece of paper in front of you and tells you to sign it. And the person standing beside you, the person who was supposed to be your partner, your protector, the person who promised in front of 200 people to stand by your side, says nothing. Not a word, not a question, not even a look that acknowledges what is being asked of you, just silence. And the faint, almost imperceptible nod of someone who has already made a decision and is waiting for you to catch up with it. That was the moment I understood that my marriage was not what I had believed it was. Not because of the paper, though the paper was bad enough. Because of the silence. Because of the nod. My father-in-law placed a legal document on the kitchen table of the house I had lived in for 6 years, and told me to sign away my ownership stake in a property that I had purchased with my own money before I ever met his son. He had brought a notary. He had arranged it in advance. He had told David beforehand, my husband, who stood in that kitchen and said nothing, and the two of them had decided, between them, in conversations I had not been part of, that this was how it was going to go. He said, and I remember these words with the specific clarity that comes from words that change the shape of your life, sign it or consider what it means for this marriage. That was the choice, my property or my marriage. I signed it. And in signing it, I made the worst and the best decision of my life simultaneously. The worst because it was wrong, because I was coerced, because no one should ever be made to make that choice. And the best because of what happened in the 4 years after that kitchen table, because of what I found out I was capable of when everything I thought I had was gone. My name is Claire. And I am going to tell you exactly what I built without their help. Stay with me. I need to start with the property because understanding it means understanding everything that came after. I purchased the property when I was 28 years old and single. A small commercial unit in a neighborhood that was, at the time of purchase, considered unfashionable, the kind of area that experienced investors look at early and everyone else looks at after. I had been working in commercial real estate for 5 years by then, and I had learned enough to understand the difference between a neighborhood that was declining and a neighborhood that was simply waiting. I bought it with savings I had accumulated over 6 years of working, living carefully, and making no significant financial decisions without thinking them through completely. It was the most money I had ever spent. It was also, as I understood with considerable certainty at the time of purchase, the best financial decision I had ever made. I met David 8 months after the purchase. We dated for 2 years, married in a ceremony that I remember with genuine warmth because the day itself was exactly what I had wanted. Small, honest, full of people I actually loved. I moved into his family's property after the marriage, a house that was technically David's but practically Walter's, a distinction I understood in theory and had not yet understood in practice. My property remained mine. It was generating rental income. It was appreciating. It was, in purely financial terms, the most valuable thing I owned, and the thing I had built entirely alone, before David, before the marriage, before any of the structures that Walter would later try to use against me. Walter had been looking at my property since the beginning of my marriage. I understood that later. At the time I simply noticed that he asked about it more than the subject warranted, its current value, the rental terms, what my long-term plans for it were. I had answered openly because I had nothing to hide, and because it had not yet occurred to me that the questions were preparation. They were preparation. The document he placed on my kitchen table 2 years into my marriage was a transfer of ownership. Fully drafted, notarized and ready for my signature. Transferring my property, purchased entirely with my own money before the marriage, held entirely in my name, into a family trust controlled by Walter Reed. I want to reconstruct that evening as precisely as I can because I think the details matter in a way that a summary does not capture. It was a Thursday. I had come home from work to find Walter's car in the driveway, which was not unusual. He visited frequently and without advance notice in the specific way of someone who believes that the homes in his family's orbit are his to enter at will. He was sitting at the kitchen table when I walked in. David was standing near the counter, not sitting, not settled, in the specific posture of someone who is waiting for something to begin and does not want to be too comfortable when it does. The document was on the table, face up, beside it a pen. Beside the pen, a notary stamp and a woman I did not recognize who was introduced to me simply as a witness. Walter did not preface it. He did not build toward it. He said, "Sit down, Claire." I sat. He explained in terms that were businesslike and entirely devoid of acknowledgement that this was my property he was discussing, that the family's financial arrangements required consolidation, that the trust needed to include all relevant assets, that my property, he called it, the commercial unit on Marsh Street, as if the possessive had already transferred, should be part of that structure. I said, that property is mine. I purchased it before the marriage, it is not a marital asset. He said, I understand that. This is not about legality, this is about family unity. I looked at David. David looked at the counter. Walter said, sign it or consider what it means for this marriage. I sat with those words for approximately 30 seconds. I looked at the document. I looked at David, who was still looking at the counter. I looked at the notary, who was looking at the table, and I made the worst decision of my life. I signed it. The notary stamped it. Walter picked it up without looking at me. He said, thank you, Claire, in the tone of someone who has completed a transaction. He stood. He left. The notary left. David and I did not speak for the rest of that evening. I sat at that kitchen table for a long time after they were gone. Not crying, I was past the tears, already somewhere colder and more focused than tears. Trying to understand what had just happened. Trying to understand what it meant about the marriage I was sitting inside. I had my answer before I went to bed. I simply was not ready to act on it yet. I want to be honest about what the 3 months following the kitchen table looked like, because I think honesty about the difficult period matters more than skipping to the recovery. I stayed. For 3 months after the signature, I stayed in that marriage, not because I had decided to forgive what had happened, but because I was processing it, and I do not process things quickly when the stakes are significant. I was gathering my thoughts. I was assessing the situation with the specific precision of someone who has learned, from working in real estate, that the worst decisions are the ones made at the height of emotion. I was also, during those 3 months, doing something else. I was documenting every conversation with Walter that related to the property, every instance of David failing to advocate for me in dealings with his father, every piece of correspondence I could access, every record of the original purchase, the transfer, the circumstances under which the signature had been obtained. I kept records with the methodical attention of someone who has worked in commercial transactions for years and understands that documentation is the difference between a grievance and a case. I also called Amy, my best friend of 12 years, the most practically intelligent person I know. I told her everything over a 3-hour dinner that I had pretended to David was a work event. She listened without interrupting. When I finished, she said, how much of this is documented? I told her. She said, then you have more than you think you have. What you need now is the right attorney. She was right. I found Sandra Mills the following week. Sandra Mills had been practicing civil and property law for 19 years. She was recommended to me by a colleague who had described her as the kind of attorney who does not look for the fastest resolution. She looks for the right one. I brought her everything. The original purchase documentation proving the property had been acquired entirely before the marriage with entirely my own funds. The transfer document Walter had produced. The timeline of events leading to the kitchen table. My documentation of the 3 months since. Sandra read through the materials with the attention of someone who is building something rather than simply reviewing. When she looked up, she said, tell me exactly what he said, the exact words. I told her. She was quiet for a moment. Then she said, Claire, what you are describing is coercion. A signature obtained under explicit threat, specifically, a threat to your marriage, is not a valid legal instrument in the way that Walter appears to believe it is. The fact that he brought a notary does not make this a clean transaction. The fact that the threat was witnessed changes this significantly. I said, the notary witnessed the threat, Sandra said. The notary witnessed the threat? She looked at me directly. I want to be honest with you about what this process involves. It will not be fast. It will not be comfortable. Walter will have legal representation and he will fight this. You will have to be prepared to go through the documentation of your marriage and your financial history in detail. Are you prepared for that? I said. I have been preparing for 3 months. She said, good. Then let's begin. I walked out of Sandra's office and called David. I told him I had retained an attorney and that I was pursuing the return of my property through legal proceedings. He was quiet for a long moment. Then he said, Claire, are you sure you want to do this? I said. David, I was sure the moment your father told me to sign. He did not respond. 3 weeks later, I moved out of the house and into an apartment. The marriage was over in every practical sense. The legal proceedings ran in parallel with the separation and were finalized together 8 months later. The legal process was exactly what Sandra had warned me it would be: long, detailed, and uncomfortable in the way that any proceeding is uncomfortable when your private life becomes the subject of formal examination. Walter's attorney argued predictably that the transfer had been voluntary, that I had signed without compulsion, that the notarized document was a valid instrument, and that my subsequent claim of coercion was a retrospective reframing designed to recover an asset I had freely transferred. Sandra's counterargument was built on 3 pillars. The first was the timeline and circumstances. The transfer had been arranged without my prior knowledge, presented without advance notice, and executed in a single sitting without any opportunity for independent legal review, a standard that any legitimate property transfer would involve. The second was the testimony of the notary herself. This was the element that Sandra had identified early as potentially significant. The notary, a woman named Patricia Green, who had been hired by Walter through a service and had no personal connection to the family, had been present for Walter's words at the kitchen table. When Sandra's office contacted her to take a statement, she confirmed clearly and without hesitation that she had heard the specific language Walter had used. She had found it uncomfortable at the time. She had not known she had grounds to refuse to notarize under those circumstances. When Sandra explained that her testimony was significant, Patricia Green did not hesitate. She provided a sworn statement. The third pillar was the financial documentation establishing the property's origins, every record of the purchase, the source of funds, the timeline establishing that it had been acquired entirely before the marriage using entirely premarital funds. This established that it had never been a marital asset in any legal sense, and that Walter's claim of family unity had no basis in the financial or legal reality of the property's history. Walter's attorney shifted strategy midway through the proceedings when it became clear that the notary's testimony was not going to be successfully challenged. The new strategy was settlement. Sandra called me on a Tuesday afternoon with the settlement offer. It was not the full return of the property. It was a financial settlement representing a significant portion of the property's current value, which, in the years since the forced transfer, had appreciated considerably. Sandra told me the offer was reasonable given the costs and timeline of continuing to full judgment. She also told me that in her professional opinion the case was strong enough to proceed, and that proceeding might yield a better outcome. I asked her, "What would you do?" She said, "I would take the settlement and use the money to build something they cannot take." I took the settlement. The settlement was substantial, not the full value of the property, but enough. Enough to do what Sandra had said. Enough to build something they could not take. I had spent 8 months separated from a marriage, going through a legal process, living in an apartment that was mine rather than belonging to anyone's family trust, and thinking with more clarity than I had had in years about what I actually wanted to build with my life. The answer was what I had always known how to do. Commercial real estate, not working for someone else's portfolio but building my own, not a large fund, not an ambitious institutional play. A focused, deliberate, carefully chosen portfolio of exactly the kind of property I had been good at identifying since I was 23 years old. James had been a professional contact for several years, someone I had worked alongside on 2 commercial transactions during my previous role. He had left the same firm 6 months before everything with Walter happened, and had been building an independent advisory practice in the commercial property space. I called him 3 weeks after the settlement cleared. I told him what I wanted to build and why. I told him about the settlement and what I intended to do with it. I asked if he wanted to build it with me. He said, "I have been wondering when you were going to do this." I said, "The timing was not up to me." He said, "It is now." We incorporated the company the following month. I brought the capital and the property identification skills. James brought the client network and the transaction infrastructure. We were, from the first day, exactly the kind of partnership where each person makes the other more effective rather than simply doubling the headcount. Our first acquisition was a commercial unit in the same neighborhood as my original property, the one Walter had taken. Not the same building, the street adjacent. I chose it deliberately, not for revenge, but because I knew that neighborhood better than any other, because I had been right about it 6 years earlier and the appreciation had proved it, and because starting where I knew was the most rational decision available. It was also, I will admit, satisfying in a way that had nothing to do with rationality. What we built over the following 2 years was not the largest commercial real estate operation in our city. I want to be precise about that because I think the value of this story is not in the scale of what I built. It is in the fact that I built it at all, from a settlement payment, after losing a property I should never have lost, in a period when everything was simultaneously going wrong. What we built was real. 3 properties in the first year, 2 more in the second. A client advisory practice alongside the portfolio that generated revenue independent of the asset appreciation. A reputation in our market for finding exactly what people had stopped believing was findable, the undervalued property in the neighborhood that was waiting rather than declining. I was good at this. I had always been good at this. Walter had known that. His interest in my property had not been random. It had been the specific interest of someone who recognized value and wanted to redirect it toward himself. Understanding that he had recognized my ability, even as he tried to exploit it, was something I found useful rather than infuriating. It told me that the assessment I had always had of my own skills was accurate. That the property purchase at 28 had not been luck. That what I had built since the settlement was not beginner's fortune. My mother called me regularly throughout this period. She had been consistent in the way she had been consistent my entire life, not intrusive, not managing, simply present. One evening she said something that I have thought about often since. She said, "I told you the day you signed that paper that it was the beginning of your freedom. Do you remember?" I said, "I remember. I did not believe you at the time." She said, "I know, you had to find out for yourself." She was right. I had found out for myself. I want to tell you what I know about Walter in the period since the settlement, not because his story is the point, but because I think the honest accounting is more useful than a triumphant summary. Walter did not take the settlement quietly. He was, by every account that reached me through mutual professional connections, furious in the specific way of someone who expected to win and did not. The legal costs of contesting Sandra's case had been significant. The settlement he had ultimately agreed to had returned substantial value to me. The notary's testimony, the detail he had apparently not anticipated when he arranged the kitchen table, had been the thing that made the outcome unavoidable. He had miscalculated on Patricia Green. He had assumed that a notary was a functionary, someone whose job was administrative and whose personal observations were irrelevant. He had not understood that a notary is a witness and that a witness to a specific set of words, willing to confirm them under oath, is a material fact in a coercion case. He had also miscalculated on me. He had looked at a woman who had signed a document under duress and concluded that the signing meant she was the kind of person who could be managed by pressure. He had not understood that signing had been the most practical choice available in that moment, and that practical choices made under pressure are not permanent positions. David and I finalized our divorce 8 months after I moved out. He was not unkind during the process, I want to give him that. He was also not brave or clear or honest in any of the ways that might have made the outcome different. He was simply a man who had chosen his father over his wife when the choice had been required of him, and who appeared to understand, in the aftermath, that the cost of that choice had been higher than he had expected. He reached out once about a year after the divorce was final. A message that was sincere and that I believe reflected genuine regret. I replied briefly and kindly, "There was noth."